Yes, Mr. Billara.
If it pleases your lordships, I appear for the appellant who is in attendance this morning. My learned friend, Mr. Tommen, appears for the Secretary of State. Your lordships, if I may start by simply saying that the appellant's challenge is set out in the grounds of appeal and in the skeleton argument. So I will try and be economical in the submissions I make today. Your lordships will also note that I appeared at the first tier tribunal and before the upper tribunal. This has been somewhat of a lengthy road for this appellant, and he has now given oral evidence between two previous tribunals. My learned friend, Mr. Tommen, appeared in RK and DK, and no doubt he carried a vigorous cross-examination of the appellants before the upper tribunal. There's nothing to suggest that the appellant wasn't cross-examined properly by the presenting officer who appeared at the upper tribunal at the last hearing. My primary submission, my lord, is that a striking feature of this appeal is that both the first tier tribunal, when granting permission to the upper tribunal, and the upper tribunal, when granting permission further, found that it was the quality of the oral evidence of this appellant that really rested upon whether there was a material error of law. That is found firstly at Judge Addio's decision, which is found at page 71 of the bundle. First tier tribunal Judge Addio's decision.
So which bundle are we in?
It's the court bundle, so the main court bundle. It's page 71.
Page 71 is the second page of the Home Office refusal letter in my copy of the court bundle.
Well, Judge Addio's decision in our bundle starts at page 70.
Oh, well, I don't know how that's happened. I think it's page 60 in what we have.
Oh.
It was heard in Newport, is that right? Oh no, wait, sorry, no. That's the decision of Judges Davidge and Heaven.
That's correct, my lord. Yes.
So where's Judge Addio gave the permission to appeal?
Yes, that was on the 16th of November 2020.
Yes, sorry. That I'm being slow catching up. That is at page 47.
Ah.
Do my lords have a supplemental bundle?
Yes.
Yes, as of yesterday.
That's the pagination that my learned friend is referring to.
That's the bundle that we're working on, my lord.
What, the supplemental, not the core?
It is.
If it's if I may say so, I wasn't going to give everyone a hard time. The paperwork's been a complete mess for this. We've had late authorities bundles. Most of the authorities in them aren't relevant anyway, and the. I have to say that the grounds of appeal are not in the form grounds of appeal ought to be in.
Sincere apologies.
Well, don't worry, we are where we are, and I wasn't to say any of this,
yes.
but
no, I'm
being provoked.
I'm grateful.
But we are where we are. As long as we all use the same bundle, it doesn't matter. The supplemental bundle is not normally where you find the main.
I agree, my lord.
But and I've been using the core bundle, but I don't mind in the least using. Here we are. Yes, page 71. So
great, my lord. Yes. So that is first tier tribunal Judge Addio's decision, which is granting permission following Judge Davidge's dismissal of the appeal. We then have upper tribunal Judge Lane's decision.
Well, what in particular were you trying to draw our attention to?
Well, paragraph 2 and paragraph 2, in essence, Judge Addio raises concern as to whether the first tier tribunal had properly considered all the relevant material and all the relevant evidence that the appellant had put forward before the first tier tribunal, not only in its oral evidence, but also its documentary evidence.
I haven't, I'm afraid, given this a great deal of attention because we're not interested in the first tier decision anyway. At the moment, I don't see what you get out of Judge Addio's decision.
Well, the point that's being made, Your Lordships, is that in the decisions where permission has been granted previously, not only by the first tier tribunal, but also in upper tribunal Judge Lane's decision, which is found at page 69 of this bundle.
Yes, that's not so much a permission decision, that's actually
Yes.
That's allowing the appeal.
Allowing the appeal.
Yes.
It's the quality of the oral evidence. I think that's the point we want to put forward. The quality of the oral evidence throughout has always raised some concern with decision makers who are looking as to why an appeal has been dismissed, which then brings me to this particular tribunal.
I just want to make sure. I'm not quite sure that is what those decisions say, but in a sense that doesn't matter. That was the oral evidence given first time round.
Yes.
We started with a clean slate.
Indeed.
In the upper tribunal when the decision was remade. You may have points to make about the oral evidence there, and we've got the notes, and I'm going to hear your points, but all this prehistory doesn't really get us anywhere, does it?
My lord, perhaps I can just put it very differently. The oral evidence that has been given by the appellant has been consistent throughout. Perhaps that's a different way of putting it. And before the upper tribunal, there is a note of hearing, which no doubt your lordships would have considered with care. It does have the hallmarks of almost an exchange between the bench and the advocates who were present on the day, rather than a blow-by-blow account of how the appellant answered during his cross-examination.
Well, the first thing to say about this note is it an agreed note?
It is agreed.
I mean,
there has been
you don't have to look at it. It may be agreed, but it can't be agreed as a perfect note because there are bits that don't make sense and bits that are a bit possible to understand.
Yes.
It's not a criticism; it's a running note by the solicitor who was there. But
I agree, my
lord. It's got to be read with a little care.
I agree, my lord.
Okay,
yes. Just gleaning from that note in the round, it can be said with a fair degree of confidence that the appellant was properly cross-examined, yet again by a presenting officer. His oral evidence did not demonstrate that there was any hesitancy or implausibility in any of his answers that he gave when put under very proper cross-examination by the Secretary of State. The concern that this court expressed when granting the provisional grant of permission is really in relation to the first ground of appeal, that the upper tribunal did not consider the oral evidence with the requisite care that it should have done. At paragraphs 24 to 26 of Upper Tribunal Judge O'Callaghan's determination, which is found at pages 56 and 57 of the bundle, in those paragraphs, there is very helpfully a recital of the evidence or a summary of the evidence given by the appellant. But none of those features of his oral evidence, my lord, and I say this respectfully, are actually found in the overall conclusions.
Well, what features are you referring to?
The appellant gave consistent evidence throughout in relation to how he took the test, his travel to the test centre, why he chose that particular college.
Let me just make a note. Travel to the test centre?
Yes, travel to the test centre, why he chose that particular college. How many candidates he recalled seeing at the test centre. And paragraph 25 of the Upper Tribunal decision, Upper Tribunal Judge O'Callaghan actually does refer to one particular question put forward by the presenting officer in relation to whether he could identify the same people who attended the test on 2 different days. So there were specific questions asked of this appellant at the Upper Tribunal. That particular question, in fact, wasn't asked previously of this appellant in the first tier tribunal.
But what important point for the appellant comes out of the evidence that he gave about how he got there? That would be relevant in some cases in the old days. Certainly, I've only had a patchy acquaintance with these, but I've seen some appeals from them before, where there's an issue about whether someone attended at all.
Yes.
But it's now clear from RK and DK that these the modus operandi at New College London and no doubt others was you did attend. You just didn't take. You just stood away while the proxy took the test.
Yes.
So how he got there is neutral. Why chose this college? Again, that's often an important point where someone, instead of going to the college around the corner, travelled somewhere 3 hours away, and
Yes.
there was an inference being drawn by the Secretary of State that you chose the further one way because you knew that they would allow you to cheat. But it's a really neutral issue here, isn't it? He went to the nearest one, but if the nearest one was one that allowed him to cheat, that doesn't get you anywhere.
My lord, perhaps the simplest way to resolve this feature of the appellant's case is by looking at paragraph 131 of RKDK, which
Yes,
essentially.
Well, let me find it first. Oh, I haven't. Annoyingly. Again, because we didn't have proper authorities bundles, I printed it out loose and it hasn't reached me here. But hang on, I can find it on.
No, I'm grateful, my lord.
Paragraph 131.
131. Yes, my lord.
Just give me a moment. If it's important, I'll have to get hold of it. But I think I read RKDK.
Yes.
Perhaps just read it out.
I'll simply just summarise what, in essence, the upper tribunal. I mean, I'm not going to be mealy-mouthed the fact that New London College was they had a propensity.
It was a fraud factory. I know.
Yes, it was a fraud factory. However, what RKDK, the upper tribunal, was very cautious about, is not to treat all candidates who took the test at New London College in the same manner as the very ugly case of Cambridge College of Learning. And that particular college reared its ugly head during the discussions with Upper Tribunal Judge O'Callaghan. Paragraph 131 of RKDK makes it very clear that an appellant may discharge an evidential burden by giving plausible and credible evidence. A mere assertion that he was honest and a mere assertion that he took the test will not suffice. The quality of the oral evidence, therefore, Your Lordships, is very important. And in RK and DK...
Yeah, but we can't judge the quality of the oral evidence. Well, I suppose there's 2 points here. The first one is the typical. The judge is there and has to decide whether he believes the appellant. But it's not a situation where the circumstances are entirely neutral, and if someone gives apparently plausible and consistent evidence, you ought to believe them, because why wouldn't you? It's a case where, as RK and DK makes pretty clear, the fact of the ETS test result being invalid,
yes,
i.e. the ETS system detected a proxy, and the lookup tool, that's to say the chain of custody, being reliable, means that someone who comes and gives evidence saying it wasn't me has a very heavy burden to shift, and it may not be enough just to say it wasn't me, even if you say it wasn't me. Sorry, it was me. I should say,
yes.
Saying it was me